Okay. Okay, we are live, and this is Senate Health and Welfare back again on January 10th, and we're going through a series of bills with Ledge Council, and we have with us Jen Carvey. So Jen, welcome.
Thank you.
So,
for the record, Jennifer Carvey, Legislative Counsel, and I think we're starting with S-162, an act relating to extending the moratorium on home health agency certificates of need.
and I'll just say that I was approached by folks from long-term care to introduce the bill, and then made a suggestion that we maybe look at how our committee might respond to this request, and then also ask the House Human Services to look at it, and maybe it would fit into another bill because it's a very short piece. So Jen, why don't you share with us what's going on?
Okay, so you put the language up on the screen. And you can see S-162. And the statement of purpose really says it most clearly, but I can show you what the language does and gives you a little history too. So the statement of purpose, as it says, the bill would extend the moratorium on certificates of need for new home health agencies until 2030. Certificate of need, I can't remember if we've done certificates of need here, but to the extent that we have, in this committee, this biennium, to the extent that we have or have not, the certificate of need is something that the Green Mountain Care Board issues when a healthcare provider facility is looking to do an expansion to an existing facility, to create a new facility, to offer a new service that's expected to have a somewhat significant financial impact. And the certificate of need, when the jurisdiction is triggered, is to determine whether there is in fact a need for the services that are proposed to be provided if the entity goes forward with the project. So initially, you can see this has been a provision of session law that was initially enacted in 2010. That is when the first moratorium went into effect, and there had been some concerns, as I recall at the time, about the nonprofit and for-profit home health agencies and the nonprofit ones, which is, I think at this point, all of the home health agencies that are operating in the state, because I think the one that wasn't has become one. But those that are not for profit have a requirement to take all patients who need their care. There are not similar requirements on for-profit ones, and so this had been a pause, saying don't grant any new certificate of need for a new home health agency, including hospice, or for somebody in existence to offer home health services for a period beginning on the effective date of this act, which was back in 2010, and continuing through, and the date has been extended. So right now it's in place through January 1st of next year. This would push that out until 2030, or until the General Assembly lifts the moratorium after considering a progress report on the Green Mountain Care Board's implementation of its healthcare reform initiatives, health planning function, and how they relate to home health agencies, whichever occurs first. To my knowledge, that I'm not aware that there has been a report on that, and so the General Assembly has not specifically contemplated lifting it, other than the date that's already in here. And then the section 2 is really a conforming change. There's this periodic health planning function progress report requirement saying as long as that moratorium is in place, the Green Mountain Care Board will provide any updates that the board generates on its implementation of its healthcare reform initiatives and health planning function and how they relate to home health agencies. So the change that is being made in section 2 of this act is to amend section 2 of earlier acts that is just describing the moratorium and how it's been extended. And then section 3 would have this take effect on July 1st.
So questions on this. I understand that House Human Services is making a recommendation to put this language into the Budget Adjustment Act. And should that happen, then we would also want to have testimony going forward to understand the implications, unless the committee is fine with it as it is. That's it. Yeah, go ahead.
So this is this would be the fourth time we would extend this, right? Or the
Yes, it would be the fourth time it would be extended. So it was enacted in 2010, extended in 2013, 2016, 2019, and this would be 2020.
Okay, so I completely understand why we have this moratorium, and I'm supportive of it because I think there's a fear that the for-profit organizations would come in and cherry pick all the wealthy patients, and then the nonprofits would, kind of like what happens with schools. But anyway, so I am supportive of this, but I also am concerned when we have something that we're just continuing to extend a deadline. And I'm wondering if we might want to look at changing some of the requirements about home health agencies and who they need to serve, whether they're for-profit or nonprofit, and do a sort of bigger look at it.
So my suggestion that I've actually made both to Health and Human Services and the others is that we do put guidelines in place, and that if the concern is that when a for-profit purchases one of these long-term care facilities, that they tend to go bankrupt because they don't last. It's an equity investment, and then it's not profitable, so they sell it or they declare bankruptcy. And so I do think taking testimony on it would be helpful, and then making suggestions about how to protect our current, any long-term care facility that we have.
But this is home health.
I'm sorry,
specifically.
home health, I apologize, I always do that, my fault. Who happened to walk in just as I said, made that big mistake. Home health, and that we could put some language in that's protective, that if there's a for-profit purchase, then the home health facility would be maintained at equal or better.
Again, this is home health agency services. These are services, there's no facility typically. They're
Yeah.
going out to the patient's home and providing the service in the home.
Understood.
Right,
So-
so I mean, we could, there are a lot of protections we could put in place that would prevent the cherry picking and prevent the, so I feel like we continue to put this Band-Aid on rather than dealing with the
Oh,
issue.
agree. So what we might do is, we're not gonna do it today, obviously, but what we might do is to ask someone who knows about home health agencies and the concerns, to come in and provide testimony, and then make suggestions about what we could do to offer protection, so we don't have to keep doing this. It might go on its merry way in the House, and then once we have language, if it is in the BAA, maybe we can influence that language. If we can do it that quickly, it'll take a while. Or we can put it into the budget, or we can put it into our own bill. Yeah, I agree with that.
Yeah, or we could put some provision in place that requires legislation, and I'm happy to work on that if I'm still here next year.
Yeah, we can do that.
If.
So, Jill Olson is here, and you heard that, so maybe you could help us with some thoughts on that going forward.
I'll do that.
Good. We might come back to this today.
Okay.
I don't know we might have some time at the end, we'll see. If you have time to sit. Okay, so S-173. Okay, and this is related to the work that we did on Article 22, and other bills related to Article 22, and ensuring that there's some protection for folks when they seek reproductive health care and prescriptions. So the bill, I couldn't remember whether we modeled it after Washington State.
I wanted to say Colorado, but you might be right.
Colorado.
No, you're right, Washington.
That's what I thought.
Yeah.
Okay, we did. All right.
Yes.
So why don't you just go right ahead?
Okay. So this is S-173, an act relating to the collection, sharing, and selling of consumer health data. And as the chair said, this is modeled very heavily on the Washington law, which is also called, I think in their case, Washington My Health, My Data Act. This one would be creating a new subchapter in the existing chapter in Title 18 on healthcare privacy. So first it would just create a subchapter for the existing provisions in that chapter that would be on disclosure of protected health information. And then subchapter 2 would be this Vermont My Health, My Data Act with its own short title. And it has findings and intent. So the findings start with the view of Vermonters that their privacy is a fundamental right and an essential element of their individual freedom, and that fundamental privacy rights have long been and continue to be integral to protecting Vermonters and safeguarding our democratic republic. And the second finding relates to the sensitive nature, personal and sensitive nature of information related to an individual's health conditions or attempts to get healthcare services, and that Vermonters expect their healthcare data is protected under laws like HIPAA. It's true, but HIPAA only covers healthcare data collected by specific healthcare entities, including most healthcare providers. Healthcare data collected by non-covered entities, including certain applications and websites, don't have the same protections. So this act, it says, is working to close the gap between consumer knowledge and industry practice by providing stronger privacy protections for all of Vermont consumers' health data. Then it gives some intent statements. By enacting this act, is the intent of the General Assembly to provide heightened protections for Vermonters' healthcare data by requiring additional disclosures and consumer consent regarding the collection, sharing, and use of their health data, empowering consumers with the right to have their health data deleted, prohibiting the selling of consumer health data without valid authorization signed by the consumer, and making it unlawful to utilize a geofence, which, don't worry, is defined in the bill, around a
I love
facility
this term.
that provides healthcare services. So almost half of this bill is just definitions. So I won't go into all of them, but some of them, I'll just name some of the terms and then go into more of the details in some of them that show up a lot. So the definition of abortion, which is used sort of tangentially with respect to some other definitions. Affiliate, what it means to be an affiliate, because we're regulating both businesses and their affiliates. Authenticate, another term that's used. Biometric data, I wanted to stop on because this is something that is used in the bill and is necessarily a known definition. So in this case, it's data that is generated from the measurement or technological processing of an individual's physiological, biological, or behavioral characteristics, and that identifies a consumer, whether individually or in combination with other data. And biometric data includes imagery of the iris, retina, fingerprint, face, hand, palm, vein patterns, and voice recordings from which an identifier template can be extracted, and keystroke patterns or rhythms and gait patterns or rhythms that contain identifying information. So a pretty broad view of biometric data.
Yeah.
Interesting.
That is, yeah.
AI, that's something to do with AI, artificial intelligence.
No, but it's something to do with a camera taking your picture or someone invading your computer while you're typing and understanding that it's you and identifying you when you're making an order online or communicating information.
What about a health app? Like, what about, like, my watch, for
So
example?
we're gonna get,
We're gonna get to
well,
that?
Keep going.
we're gonna get, I mean, it doesn't say nobody at any time, there's just, it's consent. You would need, so your app likely has asked you to agree to something before it started tracking you. Or it would need to under this.
Right. Okay.
All right, so then we have
Fine print.
what it means to collect consumer health data. Consent in this case is a clear affirmative act that signifies the consumer's freely given, specific, informed, opt-in, voluntary, and unambiguous agreement, which may include written consent provided by electronic means. It talks about how consent shall not be obtained by consumers' acceptance of a general or broad terms of use agreement or similar document that contains descriptions of personal data processing along with other unrelated information. Consent is not a consumer hovering over, muting, pausing, or closing a given piece of content, or a consumer's agreement obtained through the use of deceptive designs. We get to a consumer, so who are we talking about in the context of this bill, whose personal information we're looking at? A consumer is a natural person who meets one or both of the following conditions. They're a Vermont resident, or their consumer health data is collected in Vermont. So if you're not a Vermont data, but you're visiting Vermont and your data is being collected, then you would fall under the definition of consumer. And a consumer is a natural person who acts only in an individual or household context, however identified, including by any unique identifier. It's not someone acting in an employment context. Now, we have consumer health data is personal information that is linked or reasonably linkable to a consumer, and that identifies the consumer's past, present, or future physical or mental health status. And for purposes of the definition, physical or mental health status includes individual health conditions, treatment. I'm not sure what that's supposed to say. It says treatment diseases. That's not it. Treatment of diseases.
No, that's
treatment
wrong there.
or general. Let me just note that for myself.
Of diseases.
All right.
For diseases.
I don't know, or treatment, diseases. I don't know what it's supposed to say. So I will go back to the Washington version to decode that one. So health conditions, treatment of diseases or diagnosis. Social, psychological, behavioral, and medical interventions, health-related surgeries or procedures, use or purchase of prescribed medication. Well, I apologize.
I did notice that, and there's another bill where I
Sometimes
found
you don't
some-
notice the typos until you read them out
I
loud.
found some typo. I didn't find the typos before it was sent in. An editor didn't say it.
Oops, it wasn't wrong.
The bill we're looking at on
Use or
Friday has a
purchase
typo in it.
of prescribed medication, bodily functions, vital signs, symptoms, or measurements of the information described in this long list, diagnoses or diagnostic testing, treatment, or medication, gender-affirming care information, reproductive or sexual health information, biometric data, genetic data, precise location information that can reasonably indicate a consumer's attempt to acquire or receive health services or supplies, data that identifies a consumer seeking healthcare services, or any information that a regulated entity or small business or its processor processes to associate or identify a consumer with the data described in that list that is derived or extrapolated from non-health information, such as proxy, derivative, inferred, or emergency data by any means, including algorithms or machine learning. And then it talks about what consumer health data does not include. It does not include information used to engage in public or peer-reviewed scientific, historical, or statistical research in the public interest that is being regulated in other ways. So we'll go into all of those in that moment. Deceptive design, what it sounds like. De-identified data, we talk about fairly frequently, but it's data that cannot reasonably be used to infer information about or otherwise be linked to an identified or identifiable consumer or a device linked to them if the entity that possesses the data does all of the following. Takes reasonable measures to ensure the data cannot be associated with the consumer, publicly commits to process the data only in a de-identified way and not attempt to re-identify it, and contractually obligates any recipients of the data to satisfy those criteria. Gender affirming care information is personal information about someone seeking or obtaining past, present, or future gender affirming healthcare services. The reason I'm going into this is because it includes precise location information that could reasonably indicate someone's attempt to acquire or receive those services, efforts to research or obtain the services, or any gender affirming care information that is derived, extrapolated, or inferred, including from listed sources. And then we use gender affirming healthcare services has the same definition that we worked on last year in this committee. Genetic data is any data regardless of format concerning a consumer's genetic characteristics. It includes raw sequence data that result from sequencing a consumer's complete extracted DNA or a portion of it, genotype and phenotype information resulting from analyzing raw sequence data, and self-reported health data that a consumer submits to a regulated entity or small business and analyzed in connection with their raw sequence data. Here's the geofence. Geofence is technology that uses global positioning coordinates, cell tower connectivity, cellular data, radio frequency identification, Wi-Fi data, or any other form of spatial or location detection, individually or in combination, to establish a virtual boundary around a specific physical location or to locate a consumer within a virtual boundary. And for purposes of this definition, a geofence is a virtual boundary that is 2,000 feet or less from the perimeter of the physical location. Sort of this conceptual fence around a physical location that is identified using one of these kinds of location detection resources. Healthcare service, long list of things we can go through at some point, maybe not now, so we can get to what the bill does. But healthcare service provided to a person to assess, measure, improve, or learn about their mental or physical health, including a long list of potentials. Okay. Homepage, pretty much what you think for homepage. Person, when it's using just the term person, can mean a natural person or an entity, which is consistent with our definitions in Title I. Personal information, information that identifies or is reasonably capable of being associated or linked directly or indirectly with a particular consumer. It includes data associated with a persistent unique identifier, such as a cookie ID, an IP address, a device identifier, or other form. Does not include publicly available information or de-identified data. Precise location information is information derived from technology, including global positioning system, GPS, level latitude and longitude coordinates, and other mechanisms that directly identifies the specific location of an individual with precision and accuracy within a radius of 1,750 feet. This does not include the content of communications or any data generated by or connected to advanced utility metering infrastructure systems or equipment for use by a utility. Process or processing, and processor or things dealing with people who act upon or process consumer health data. Publicly available information, talks about what that means. Regulated entities, so we're going to be regulating regulated entities here. So this is a legal entity that conducts business in Vermont or produces or provides products or services that are targeted to consumers in Vermont, and alone or jointly with others determines the purpose and means of collecting, processing, sharing, or selling of consumer health data. It's not government entities or contracted service providers when processing consumer health data on behalf of a government agency. Reproductive or sexual health information about past, present, or future efforts to seek or obtain reproductive or sexual health services. List there, similar to what we saw for the gender affirming as far as location information, efforts to research or obtain services, and information derived from other sources. Definition then of reproductive or sexual health services, and I added at the end the catch-all of anything else we talked about in the definition of 1 VSA section 150, because this is both narrower and broader in different ways. Sell or sale, exchange of consumer health data for monetary or other valuable consideration does not include a couple of limited instances. Definition of share or sharing, what that does and does not mean. Small business is a regulated entity that satisfies one or both of the following thresholds. The entity collects, processes, sells, or shares the consumer health data of fewer than 100,000 consumers during a calendar year, or the entity derives less than 50% of its gross revenue from the collection, processing, selling, or sharing of consumer health data, and the entity controls, processes, sells, or shares consumer health data of fewer than 25,000 consumers, and finally, a third party. All right, so then we get to what is required and prohibited. Section 1894 requires each regulated entity or small business to maintain a consumer health data privacy policy that clearly and conspicuously discloses the categories of consumer health information collected and the purpose for which it is collected, including how it will be used, the categories of sources from which the consumer health data is collected, the categories of consumer health data that is shared, a list of the categories of third parties and specific affiliates with whom this entity shares consumer health data, and how consumers can exercise their rights that are provided further in this subchapter. Requires the entity to publish a link, prominently publish a link to its policy on its homepage. It prohibits the entity from collecting, using, or sharing additional categories in C, and collecting, sharing, or using for additional purposes in D, categories and purposes of consumer health data not disclosed in the policy. So it can't go beyond what's in the policy without first disclosing the additional categories in C, the additional purposes in D, and obtaining the consumer's affirmative consent prior to collecting, using, or sharing that data. It is a violation of this subchapter for a regulated entity or small business to contract with a processor to process consumer health information or data in a manner inconsistent with the entity's policy. 1895 is on the collection and sharing of consumer health data, and it prohibits regulated entities and small businesses from collecting any consumer health data except with consent from the consumer for the collection with a specified purpose. That's what I was suggesting, is if you have agreed to it, it would still be okay, or to the extent necessary to provide a product or service that the consumer whose data it is has requested from the entity. A regulated entity or small business shall not share any consumer health data except with consent from the consumer for the sharing that is separate. So the first was collecting, this is sharing. For the sharing that is separate and distinct from the consent obtained to collect consumer health data. So the consumer has to consent separately to both the collection of their data and the sharing of their data, again, or to the extent necessary to provide a product or service if the consumer has requested the product from or service from the entity. Consent required under this section must be obtained prior to collection or sharing of consumer health data, and the request for consent must clearly and conspicuously disclose the categories of consumer health data collected or shared, the purpose for the collection or sharing, including the specific ways it will be used, the categories of entities with whom the data is shared, and how the consumer can withdraw consent from future collection or sharing of their data. And it prohibits the entities from unlawfully discriminating against a consumer for exercising their rights under the chapter. Then we get to what the consumer's rights are. The consumer has the right to confirm whether a regulated entity or small business is collecting, sharing, or selling their consumer health data, and to access that data, including a list of all third parties and affiliates with whom the entity has shared or sold the consumer health data, and an active email address or other online mechanism that the consumer can use to contact these third parties. Consumer has the right to withdraw consent from the collection and sharing of their consumer health data. Consumer has the right to have their data deleted and can exercise that right by informing the regulated entity or small business of their request for deletion. It says that a regulated entity or small business that receives a consumer's request to delete their healthcare data must delete the data from the records, including all parts of their network, including archived or backup systems, notify all third parties with whom they have shared the consumer health data of the deletion request. And then it directs that all of these third parties who get notice of the deletion request must honor it and delete consumer health data from their records. If consumer health data that a consumer requests to be deleted is stored on archived or backup systems, it's okay to delay the request for deletion to enable restoration of the archived or backup systems, as long as that doesn't take longer than 6 months from the date of authentication of the deletion request. Consumer can exercise their rights under this chapter by making a request at any time. Request may be made by secure and reliable means established by the entity and described in its policy. And the method must take into account the ways in which consumers normally interact with the entity, the need for secure and reliable communication of the requests, and the ability of the entity to authenticate the consumer's identity, make sure it really is that person asking for it to be deleted. Prohibits entities from requiring a consumer to create a new account in order to exercise their rights, but may require a consumer to use an existing account. Talks about what happens if the entity is unable to authenticate the request. They don't have to comply. They can ask the consumer to provide more information in order to authenticate. And they have to provide information in response to a consumer request free of charge up to twice annually for each consumer. So a consumer can't necessarily ask daily or weekly or even monthly for information about how their consumer information is being collected or shared, and expect that all to be free of charge. But they have to do it allow it at least twice a year free of charge. If requests from a consumer are manifestly unfounded, excessive, or repetitive, the regulated entity or small business can charge a reasonable fee to cover their administrative costs or decline to act on the request, and the entity bears the burden of demonstrating that the request is manifestly unfounded, excessive, or repetitive. The entity must comply with the consumer's requests without undue delay, but in all cases within 45 days after receiving the request. The entity must promptly take steps to authenticate the request, but completion of these steps does not extend the entity's duty to comply with the request within 45 days. Consumer response period can be extended once by an additional 45 days if reasonably necessary. If it's a very complex or numerous requests, the entity has to provide notice to the consumer of the extension within the initial period. There has to be an appeals process. If the consumer wants to appeal an entity's refusal to take action on a request within a reasonable time after the consumer's receipt of the decision, and they have to make that in addition to their policy and their request process. They have to make the appeal process conspicuously available. Talks more about the appeal process. Then we get to protection of consumer health data. Requires regulated entities and small businesses to restrict access to consumer health data by their employees, processors, and contractors to only those who need to have access to further the purposes for which the consumer has provided consent, or to provide the product or service. And they must establish, implement, and maintain security practices that, at a minimum, satisfy reasonable standards of care within their industry to protect the consumer health data. Then we get to processors. Processors can only process consumer health data pursuant to a binding contract with the entity, setting forth the processing instructions and limiting the actions that the processor can take with respect to the consumer health data. Processor can only process the data in a manner consistent with those instructions. To the extent possible, the process must use appropriate technical and organizational measures to assist the entity in fulfilling its obligations under this chapter. And if the processor fails to adhere to the entity's instructions or processes consumer health data in a manner outside the scope of their contract, the processor will be considered a regulated entity or small business with respect to the data, and then it takes on all of the same requirements that are imposed on the entity with which it was contracted. Limitations on sale of consumer health data. It says it is unlawful for any person to sell or offer to sell consumer health data regarding a consumer without first obtaining a valid authorization from the consumer, and the sale then must be consistent with that authorization. This authorization must be separate and distinct from the consent obtained to collect or share consumer health information. So it's lots of separate consents for different stages. Valid authorization to sell consumer health data must be consistent with this section, written in plain language, and must contain certain elements, the specific information about the consumer that the person intends to sell, name and contact information of the person collecting and selling the data, name and contact information of the purchaser, description of the purchase of the sale, including how the health data will be gathered and used by the purchaser, statement that the provision of goods or services shall not be conditioned on the consumer signing a valid authorization, statement that the consumer can revoke their authorization at any time, and a description of how, statement that the consumer health data sold under the authorization may be subject to redisclosure by the purchaser and may no longer be protected, an expiration date of 1 year after the consumer signs the valid authorization, and the signature of the consumer and the date. If there are a number of listed defects, then the authorization is not valid. If it doesn't have the information, the expiration date has passed, it's been revoked, it's become a compound authorization, it's been combined in violation of the requirement that it be separate, or the provision of goods or services is conditioned on the consumer signing the authorization. A copy of the authorization must be provided to the consumer. Seller or purchaser has to retain a copy of the valid authorization for 6 years from the date of its signature or the date when it was last in effect, whichever is later. Here are the geo-fences. So it is unlawful for any person to implement a geo-fence around an entity that provides in-person healthcare services in which the geo-fence is used to identify or track consumers seeking healthcare services, collect consumer health data from consumers, or send notifications, messages, or advertisements to consumers related to their consumer health data or healthcare services. Violations and enforcement.
So when you say to their, does that refer to the individual or is it to their more globally? I mean, all patients or can it be considered, is it considered to go right back to that individual?
I think,
Or is it considered, is that the implication here? Or,
well, it's about not using sort of where the consumer is to send notifications to consumers
Any
related
consumers.
to their
Right.
healthcare data or
Okay.
healthcare services.
Got it,
So
okay.
we see you are standing in front of a clinic that provides X
getting my
service.
mind twisted up. Good.
All right, so violations and enforcement. Violation of the subchapter will be deemed a violation of the Consumer Protection Act and gives the authority to the Attorney General then to enforce. And this is nothing in this section should be construed to preclude or supplant any other statutory or common law remedies. So just because it's a violation of the Consumer Protection Act doesn't take away anybody's additional rights they might have against and regulated entities, small business or otherwise.
Does that allow for individual lawsuits against?
This does not in and of itself create a private right of action.
It does not.
Under this subchapter, it would allow the Attorney General to pursue violations of these provisions, and it would not have any impact on rights that a consumer might have against a provider otherwise for improperly sharing their information, but it does not create a private right of action. Exemptions, the subchapter does not apply to information that meets the definition of protected health information for purposes of HIPAA. It does not apply to patient identifying information collected, used, or disclosed in accordance with 42 CFR Part 2, which is related to the cerebral substance use disorder treatment, or to identifiable private information for purposes of the federal policy for the protection of human subjects, identifiable private information otherwise collected as part of human subjects research pursuant to the Good Clinical Practice Guidelines issued by the International Council for Harmonization, protection of human subjects under certain provisions of federal law, or personal data used or shared in research conducted in accordance with one or more of the requirements set forth in this subsection. Does not apply to information and documents created specifically for and collected and maintained as part of the patient safety surveillance and improvement system. This is how the health department tracks adverse events in hospitals and other healthcare settings. Information and documents created for purposes of the Federal Healthcare Quality Improvement Act of 1986. Patient safety work product for purposes of federal law, information de-identified in accordance with the requirements for de-identification in some of the HIPAA regulations, information originating from and intermingled so as to be indistinguishable with any of that information in those earlier, that earlier list, that is maintained by a covered entity or business associate as defined under HIPAA, a healthcare facility or healthcare provider, a program or qualified service organization as defined by 42 CFR Part 2 and substance use disorder treatment, information used only for public health activities and purposes as described in under HIPAA regulations or that is part of a limited data set and used, disclosed and maintained in the manner required by HIPAA. Personal information that is governed by collected, used, or disclosed pursuant to the following regulations, parts, titles, or acts is exempt from this subchapter. Bramley-Gliley Act, certain provision of the Social Security Act, look more at what these are if you want to know, the Fair Credit Reporting Act, FERPA, the Family Educational Rights and Privacy Act, and the Vermont Health Benefit Exchange and related laws and Vermont rules. And then there's some additional disclaimers. The obligations on entities under this subchapter shall not be construed to restrict their ability to collect, use, or disclose consumer health data to prevent, detect, protect against, or respond to security incidents, identity theft, fraud, harassment, malicious or deceptive activities, or any illegal under Vermont or federal law, to preserve the integrity or security of systems, or to investigate, report, or prosecute those responsible for any such action that is illegal under Vermont law. And if an entity processes consumer health data under this previous provision, that entity bears the burden of demonstrating that its activities qualify for the exemption and complies with the section. And it would take effect on January 1st.
2025.
2025, yes. So, yes, it's fairly dense.
So this is all very clear
Yes.
and not complex.
Washington State does have some useful information on
Yes.
its implementation
Yes.
that it has on its website that we can provide as well. There are some FAQs that
Oh, good.
they have issued, their Attorney General's office has issued, but I'm happy to share.
From their Attorney General's office?
Yes.
Yeah, okay. We will have to take testimony on this one.
This is your bill?
It is.
And what happened? Why did this come about?
It is a consumer protection bill, and there are concerns in other states in particular about how reproductive health care are being utilized to target individuals. And so whether they are transgender, whether they are women seeking reproductive care, seeking medical care, abortion care, or medical treatment for pregnancy. So it's an issue in other states, and it is a concern. So this is kind of a prevention bill for our state, as far as I can see. Senator Hardy had a question, and Senator Weeks.
Yeah, thank you, Senator Lyons. Thank you for introducing this. I think this is definitely a worthy bill to take a look at. And I have a question for Jen, because I'm not sure how this would interact. So one of the first time one of the first times I started thinking about this was at a conference where, I was approached by some, lobbyist for some tech firm saying, oh, you should buy this app for your state Medicaid program. And it was an app that apparently a couple states are using, requiring women who are pregnant and on Medicaid to use a specific app to track their pregnancy. And it sort of raised some red flags for me about their data and what would become of their data. And presumably the state would have a contract with the the company that sells the app about protecting data. But I'm wondering if there's anything we should include in this bill to make sure that if the government is requiring, because if you are getting government services or government are part of a government program and the government is sort of forcing you to accept the app's privacy, terms, you're kind of being coerced into accepting it rather than freely because you want the Medicaid coverage. So I'm just curious if there's something we could add to protect people who are getting government services from having to overshare their health data, or how that
Or
would
how
work.
it's being used. is
Yeah,
the
how
critical
it
piece.
would be working.
Yeah,
So is your concern about not wanting consumers to have to consent to
Well-
using the app, an app like that, or about how their information, once collected, is used by the collecting entity?
Yeah, well, sort of a little bit of both. I mean, I think that there's a fair, I think there's a fair way that government could be using that kind of health data for public health purposes and,
right,
sort of like maternal health or whatever it is specifically is.
and that's protected in the bill. Yeah.
Well, I'm not sure it is, so that's what I'm trying to make sure we are. But I also, not only would the government have that data, but the entity that has the app would have that data. And presumably the client, the consumer, would have to agree to provide their data in order to get the public assistance benefits. They would be consenting to having their data collected by this app. And so I'm concerned about the private entity having the data, not as much with the government having the data, because there are protections about government collection of data and use of data. But
Yeah, I think
You know
we
what I
could
mean?
potentially
Do that.
put
Any contracted,
put language in here directing that the state contracts with any entity for the processing or collection of consumer health data, that has to contain certain prohibitions on redisclosure and
okay.
use of the data.
And maybe something about coercion, like that we can't require somebody to, we can't coerce somebody into using an app in order to, I don't know. I mean, it's a fine line, because I
oh, I
think,
see what you
but,
mean, yeah.
I just worry that, when I heard from this lobbyist what other states were doing, I'm not gonna name the state that was doing it, but they were collecting a ton of data
Sure.
from, women who were qualified, or pregnant individuals who qualified for Medicaid in their state. And it felt to me a little bit coercive.
Well, I wanna know what state that is.
I'll tell you offline. But I also, and while I think having that data for public health purposes may be helpful, de-identified data for public health purposes, I worry about an individual's protection of their privacy, particularly when it comes to reproductive health. Like, what if somebody gets on the app and then decides later to terminate their pregnancy? The app would know. And then there's a sort of trail of that
Well,
person's
Yeah, this will be
reproductive
an
rights.
interesting
choices.
topic to sort through.
I'm not sure how to,
Yeah.
but just wanted to put that on the table as something to think about.
Okay. Good, it's a good topic.
Yeah,
Yes.
this is a good bill. I like it.
So, thank you, ma'am. So I agree with roughly 85, or 98% of the content of the bill. But I'm curious, I come from an industry where we routinely use biometrics and precise location information in intelligence systems. Okay, we deployed them, we built them, we deployed them, we operated them. So where's the cross? Where's the line between health data and data needed to support intelligence or law enforcement activity? And because I saw nothing in there about exceptions in that world. And we're not looking for, in that environment, we're not looking for consent. We're looking for, essentially intelligence gathering information. I'm just curious.
Yeah, so frequently what you're talking about is how biometric data is used to track a criminal and to identify a criminal, for example, from genetic ancestry.com.
Variety of
all
the
that stuff.
parameters that you outline.
So,
So I'm just going back to this language near the end about the obligations imposed on entities not being construed to restrict their ability to collect, use, or disclose data to prevent, detect, protect against, or respond to bad things.
Bad thing.
Security incidents, identity,
well, that's
illegal
a
activity,
technical term.
et cetera. Or to investigate, report, or
Okay,
prosecute.
so what I would ask, if I could, Madam Chair.
Yeah, go
In the
ahead.
process of testimony, this really needs a look from, I'm not sure if it's, it's appropriate in here, or if it's gonna be passed to like, judiciary folks,
This
judiciary committee.
is, yeah,
Definitely needs a good scrub.
so.
Yes, and I think you'll want to hear from the Attorney General's office since they would be the ones enforcing it. Anyway, so then you'd be in a good position to.
The issue of how healthcare information is used by public safety has always been a topic of interest by public safety, because they'd like access to it and to be able to use it for tracking criminals. And right now, it is HIPAA protected, so this adds a layer of protection for specific kinds of data and information that is currently being abused in other states, so.
Yeah,
Yeah, I
understand the
understand what
abuse
I know
part,
what
yeah.
you're saying, and, I'm not sure that, well, we'll talk about it. Well, let's think about it. Let's think about the best way to approach this. I'm not saying we shouldn't do that, but I don't wanna open Pandora's box. That's all.
No,
But I
it's just-
understand what exactly
I
what
think
you're
it's
saying.
relevant.
It
Yeah,
does seem like this language might cover your
Yeah, I
concern, but we
think so.
should,
let's
Maybe,
make sure it
But
does.
I'd like the subject matter expert to put their fingerprint on it. Yep.
Jen, how would we do that? I mean, it may or may not be something that goes to the whole committee next door. It might be ledge counsel who deals with judicial issues, or is that not something that would work, given your
I don't,
expertise?
I think it's more about how this would be interpreted by those who are engaging in the detection and
Okay,
investigation to be sure that they don't feel that they are being unreasonably or inappropriately hamstrung by this
okay, maybe you could
language. So I
help
think
us.
the Attorney General's office, Vermont State Police,
Yes,
I don't know if Rick has other thoughts, but, they seem like,
those are the people that we should hear from.
yes, and you may want to hear from Washington's Attorney General as well to see, because this is their language, whether they have felt like it's had any.
Washington State.
Yeah, we heard from Washington State, because they do have the experience.
Did they just pass this last session?
Yeah, that's good. Right after, no, Tuesday. Colorado did it second.
I also like this
It
bill.
was,
Hello, thank you. I like this bill too. Does it
Yes.
do anything with giant corporate search engines like Google? Or
If
do
it's sending
you,
messages,
do you sort of relinquish your freedom when you start using that?
well, I asked that question about the internet, because the internet is the internet, in this case, a regulated entity, and I do believe we have
the
some
internet, because the internet is not a,
ISP,
is not a,
and,
is not a legal,
No.
the internet is not a legal entity.
okay,
So Google is a legal entity, Google is, right?
and
We don't think.
Facebook. And
Right,
all of
right,
those, but
I know.
they're conveying messages, so at the end, when you're talking
Well,
about
they're collecting
regulation.
data, we know that.
So if it conducts business in Vermont or produces or provides products or services targeted to Vermont consumers and alone or jointly determines the purpose and means of collecting, processing, sharing, or selling consumer health data, it is a regulated entity.
So yes, I would think.
How would
that-
we?
Let's talk to Washington State and see what their FAQs are, frequently asked questions are, and what their AG
I'm not sure
says.
if they're-
And then maybe we can learn from that, and then if we don't, then we're gonna have to take the next step. And we're
Did you
certainly
say
gonna
that
have
they
to hear
have a
from
website
folks
on this?
in the
They have
public
a-
safety grant.
Sounds good. Cool, thanks.
Okay. All right.
Interesting.
Any other questions for Jen? If not, we'll follow through with this one.